welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back to the next episode of Arbitration Acumen, in which we will discuss the claimant's perspective on mass arbitration with Mike Hartmere, who is the CEO of the HQ law firm PC. For those who haven't been following along, this is the fourth installment of a multi-part miniseries we're doing on mass arbitration. And in the previous 3 episodes, we had representatives from the CPR, JAMS, and the AAA discuss the procedures by which those administrators handle mass arbitration, which is really enlightening. And now we're going to hear from Mike about the claimant's approach to the process. In addition to having had a stellar legal career that spans both sides of the proverbial aisle, which you'll hear more about in a minute, Mike is an old friend and one of the most intelligent people I know. So this is sure to be an excellent episode. Let me start by just giving a couple of introductions here. I'm JP Duffy. I'm an international arbitration partner at Bracewell based in New York that acts as both counsel and arbitrator in arbitration seated around the world under a variety of governing laws and arbitral rules. I'm qualified in New York, England, and Wales, and the DIFC courts in Dubai, where I used to live and practice. With us today is Mike Hartmere. As I mentioned at the outset, Mike is presently the CEO of the HQ firm, which is a law tech firm that specializes in tracking down and suing telephone spammers and acting as class counsel in consumer class actions. Before his time acting on behalf of classes, Mike worked at 2 very large law firms in New York that would typically represent the corporate defendants in class actions. So he's seen these types of matters as well as mass arbitrations from both perspectives, and directly out of law school, Mike clerked for a federal judge in the Southern District of New York. So as you can tell, Mike has had a stellar career thus far, and he can offer a really unique viewpoint on the mass arbitration topic. So welcome, Mike, and thank you for joining us today.
Thank you for having me, JP. Great to be here with you.
Before we begin discussing mass arbitration specifically, I wanted Mike to give a bit more background on the HQ firm and their services, because I think it'll highlight how cutting edge and creative the plaintiffs' claimant side firms can be, and it'll help the audience appreciate the strategic battles that have gone on between the claimants and respondents bar in the mass arbitration space. So Mike, maybe you could just start with a little bit of background on your firm.
Sure. At the HQ firm, we focus exclusively on plaintiff side consumer protection matters, and more specifically, the Federal Telephone Consumer Protection Act and parallel state statutory cases. Historically, that meant class actions, but of course, arbitration clauses with class waivers have become ubiquitous, so the enforcement landscape continues to change. In any event, we are, in a nutshell, a data and technology-driven law firm, and a central part of that infrastructure is the Caller HQ app developed and maintained by our corporate partner, Law HQ, and its founder, Thomas Alvord. The app basically allows consumers to identify and document and preserve evidence of unlawful telemarketing calls and text messages in real time. So the app captures call metadata and other information and organizes that information in a structured format that we can use later to evaluate and substantiate potential claims. So that front-end documentation really dramatically improves claim quality and evidentiary reliability. It also allows us to assess things like consent issues and frequency of potential violations and possible statutory exposure for a defendant. And that all happens before a demand or a case is ever filed. I guess I should mention as well that what I say during our discussion today is just my thoughts and opinions, and those are not necessarily the positions my firm would adopt.
Well, that's great, Mike. And that's really why I wanted that background, because I think it really highlights how cutting edge these things are. So with that background, perhaps you could begin by explaining mass arbitration to the audience. What do you consider to be mass arbitration?
Mass arbitration is the coordinated filing of usually many dozens or hundreds or thousands of individual arbitration demands that typically arise from similar alleged misconduct. They're frequently filed by the same claimant's firm or a group of firms, and often they are the result of an employment or consumer contract that includes a class action waiver and an arbitration provision. And I suspect we'll get into this at least a little bit more later, but it's worth noting up front that mass arbitration is not a class action substitute. In mass arbitration, each claimant files an individual demand, and each of those demands must independently satisfy the arbitration agreement. So each case really stands on its own legally and often procedurally, but what is coordinated, at least in most instances in mass arbitration, is some combination of the timing and the legal theory and the administration, but it's not the aggregation of claims like is true in class actions.
Right. Now that is a really important distinction. So let's dig in on that a little bit more. So how does, just for the audience's benefit, what other ways in addition to that does mass arbitration differ from traditional class action litigation?
A class action aggregates claims into one procedural vehicle under Rule 23 of the Federal Rules of Civil Procedure, and mass arbitration involves parallel individual proceedings, at least initially. And so in mass arb, there is no certification hurdle, but there also is no binding class-wide adjudication. Another important distinction is that discovery is typically narrower and arbitrator-driven, and the arbitration proceedings can move faster, but I think practitioners would tell you that doesn't always feel true and sometimes definitely is not true. But essentially, mass arbitration is more decentralized enforcement and class action is more aggregated and centralized enforcement.
Yeah, it's a really important distinction because it's one that all the previous the guests from the administrators have pointed out as well. It's sort of two things operating at once. Like you've got, as you say, there's no binding effect on anyone outside of the specific claimants. So while you can have, I think it was Adam Shenik from the AAA was talking about mega arbitrations that he's administered where they had 200,000 plus claims. That can be a very large number of people, but any outcome can only bind those people that filed arbitrations and those people that then agreed to be bound by whatever preliminary determinations were made, which is a pretty important point. And then I guess the other one being that you really do have a process that differs materially from court in some respects because you don't have that certification hurdle that you have to get over. Now, when did you first start seeing mass arbitrations?
That's a very good question. I would say probably sometime around 2018 or 2020, maybe. And I say that because by that time, arbitration clauses with class waivers had become almost universal in consumer contracts. And that's about the time when claimants firms started really polishing up mass arb strategies. Technology matured. Case management systems improved dramatically, and claimant firms began developing kind of the operational capacity to manage scale efficiently. But I don't think it was precipitated by some watershed event. It was more of an evolution, and at least arguably it was a predictable evolution.
Yeah, that's interesting because that syncs up pretty well with what all the administrators were saying themselves, which is a lot of these things started to percolate up and they started to see indications of them before 2018, 2019, but that's when they really came to fruition. Now, if I'm understanding you correctly, you're saying that's a host of factors, but one of them being a lot of these consumer and employment arbitration clauses that had class action waivers in them started to actually develop into disputes. Did I capture that correctly?
That's right. And in my way of thinking, the genesis really goes back even farther than that, probably 15 years or so ago, to the AT&T versus Concepcion case. And then there are later U.S. Supreme Court precedents on the enforceability of class action waivers. But really, in the last 15 years, I would say many large and sophisticated corporations have been very effective in eliminating most aggregate court procedures like class actions. And so it has been an evolution. It's been a growth over time and a bit of a battle back and forth about the contours of mass resolution, particularly as I mentioned before, and I'm sure your previous guests have mentioned. You see this a lot in employment, and I see it a lot in the consumer context. So there's been a bit of a battle back and forth between the class action device on one end of the spectrum and then pure individual arbitration on the other, and mass arbitration falls somewhere in the middle.
Let's talk about that a bit, because I think that's a really interesting aspect of this that I don't think anybody has had the opportunity to get into before. And you talked about starting with Concepcion and this sort of the evolution of, I always like to think of it as almost like a drafting battle along the way in the early stages. And you and I talked about this before offline, how there's been this sort of tension is, there's like one development and then someone responds, and then there's a response to that from the other side. It'd be really interesting if you could walk everybody through that a bit, if you don't mind.
Yeah. So as I used to do for a living, and I believe you still do in many instances, in contracts, just generally, there will be a dispute resolution provision or sometimes its own contract. And the idea, a little bit oversimplified, but the idea from kind of the defendant side or the corporation side was that there were many, many large putative class actions filed by consumers or users, and these can be pretty daunting. If you have a large user base, it can be pretty intimidating to get multiple class action lawsuits filed against you every year. And so the impetus, I think, for these arbitration clauses, at least in part, was to try to take this device away from aggressive plaintiffs' counsel who would try to use the class action device as a hammer, and to make consumers or users arbitrate disputes. And the thought, really, again, oversimplified, was, hey, if I'm getting sued 10 times a year in these massive class actions, wouldn't it be better for my client if I were to just get 10 suits that had to be arbitrated individually? And so I think that was the thought. The way it's played out really is arbitration clauses have to be fair. Otherwise they are going to face unconscionability challenges from consumers. So arbitration clauses now, and for several years now, very often contain things like cost allocation or fee shifting provisions that they do make individual claims genuinely viable in arbitration. And then in the mass arbitration context, with access to a forum, some of the leverage shifts back to the little guys, so to speak. And this battle's been going on, as you mentioned, back and forth, at least for 15 years or so.
Yeah, and you're right. I do still do this, and this is something that clients are interested in, is sort of trying to manage risk, right? So I think with a lot of the way a lot of the case law developed, particularly with the Concepcion and then Italian Colors and all those cases, was you sort of started to see this pattern whereby the Supreme Court said, yeah, you can really limit the ability for people to bring collective action in court. And I think, as you pointed out, there was this notion that that's a good thing for corporations, right? At least from a risk management perspective, the class actions could be costly and troublesome and everything else, so that this would be a way to sort of scale that back. So you did see this shift in drafting. And I think you've seen, as these clauses started to get in front of courts, and particularly a lot of state courts, and you see this a lot in California, you see this a lot in the Ninth Circuit, then there would be pushback on saying, okay, this is too onerous a clause, it's not fair, it's procedurally unfair, it's substantively unfair. So you started to see these different mechanisms come in. But the end result of that is you've now got this situation where you have mass arbitration. What benefits do you see mass arbitration offering for claimants?
Yeah, for claimants, I would say, again, just access to the forum so that they're not, foreclosed from prosecuting claims. But frequently, mass arb in particular frequently will accelerate resolution. Their arbitration dockets often, but not always, move faster than federal courts. The procedures within a given arbitration can really effectively encourage compromise or resolution earlier. And in many instances, it's faster than typically is the case in the federal class action context. And so I'd say access and speed can be some of the major benefits for claimants.
Now, we're going to get into the economics of all that too, because I think that can offer, there's obviously been we should talk about this more in the context of that really intelligent strategy that came up at the outset of, filing a lot of claims at once. But before we get into that, what are some of the downsides that you see in the current system for claimants?
Well, frankly, there's a lot of risk, mainly operational risk. Many times, and I think we're going to get into this later too, but many times you'll have to mediate pretty early on. And if mediation fails, you had better be ready to actually arbitrate. And that's potentially hundreds or thousands of cases. So again, I think the pendulum has swung back quite a bit with some of the rules changes at AAA and JAMS, so that the pure terror factor, financially speaking, some call it fee bombing, but that's been mitigated quite a bit for respondents, and they're less likely to just settle because the upfront costs are too daunting. And I would just say that if you're going to take the mass arbitration path on the claimant side, you'd better be prepared to actually arbitrate. And that requires capital and staffing and process discipline. So those are the downsides or risks for claimants. But I guess I should mention too that claimant variability also matters. Consent and other defenses can vary claim by claim, and damages may differ as well. So mass arbitration requires a lot of legwork, most times a lot of money, and claimants are frequently in for a long-term commitment.
Yeah, that's really fascinating. And that's I think probably a function now too of some of the rule changes that some of the prior guests talked about. But let's talk about that a bit. And in the context of that, we could probably talk a bit about the fee bombing aspect that you mentioned. So as I understand it, and I'm not a mass arbitration expert, I just like to talk to them like you. There was this period of time in the evolution where, and I think DoorDash is a great example, where a really creative claimant side counsel came in and said, okay, if you're going to limit the ability to bring a class action in court, we'll bring a ton of arbitrations on behalf of claimants. We're going to do it all at once. And you, corporate respondent, are going to have to pay filing fees for those individual claims. Is that pretty accurate?
That is very accurate. We talked about what the provisions of these arbitration agreements typically contain, and many of them have clauses that provide that a company will pay 75 or even 100% of the upfront administrative and filing fees. And again, I think that's been done mostly to avoid unconscionability challenges. But that is an incredibly onerous financial exposure to a company before the merits of claims are even tested. So that the fee bombing, and again, it is more nuanced than this, and I don't want to upset any of my colleagues on the claimant side, but the fee bombing strategy really was, hey, if I can file 100,000 claims simultaneously, even if some of them are non-meritorious, the financial burden for the company is going to be so overwhelming that they will effectively have to settle many times before I even file. So that was a lot of leverage on the claimant side, and I'm definitely not an expert. I know your previous guests have spoken about the procedures and the costs and fees associated with using a provider like AAA or JAMS. So I don't want to get in the weeds on that because they know better than I do, but some of these rules have been changed, and I think will continue to change to make that fee bombing strategy a little less effective. And truthfully, that just strikes me as being fair.
Yeah, no, it's a really, I have to give a lot of credit to whoever came up with the notion of, and I'm using the firm, I don't mean to use the term pejoratively, but I'll just use it because it's out there, the fee bombing tactic, because it was a really smart response to that drafting battle that we talked about earlier, right? It was, look, there's a leverage point here that I can take advantage of, and I'm going to. As you correctly pointed out, I think the mere threat of having to pay, millions of dollars in filing fees before any sort of merits review could even be conducted was a pretty heavy hammer to deploy, and it was a good tactic. As you also correctly point out, I think that has now been alleviated in many ways by all the mass arbitration procedures that sort of the big three have come up with, CPR, JAMS, and AAA in this context. Although I will say, one thing that struck me from those discussions was it is still a relatively expensive process all around by comparison. And I don't know how that compares to, necessarily, for instance, class discovery in a class action litigation, but it's still relatively high. Now let's talk about that a bit, because you started to talk about some of the economics and saying, like, look, nowadays, if you're going to do this, you have to be prepared to move ahead with individual arbitration on, perhaps hundreds or thousands of cases. I think it would be great for the audience to hear a bit about, to the extent you can share it, how the economics work from the claimant side. Starting with things like, how do you go about identifying areas where these matters might come up? How do you identify potential claimants? How do you manage the cost of getting those claims filed? How do you manage, you were talking about the administrative burden. How do you manage that? All those great things. If you wouldn't mind walking people through that, I think it would be great.
Yeah. So let's start with what are you looking for on the claimant side, and particularly in the consumer context? Where can these matters come up? And I'd say in broad strokes that you're looking in the consumer context mostly for sort of uniform misconduct leading to disputes under standardized arbitration agreements. And basically you want uniform misconduct that impacts large consumer populations. What does that mean? To break that down a little bit, I think you're likely to see the potential for mass arb where you have standardized consumer contracts, really large customer or user bases, uniform alleged misconduct. And it's helpful if you're working within a statutory damages framework. So examples might be robocalls, subscription auto renewal programs, platform fee disputes, collection of biometric data, things like this. But what ties them together in my mind is that these are environments where potentially small dollar individual harm becomes very economically meaningful because you're multiplying across a big population of potential claimants. So beyond that, I would just say, just as in any litigation or arbitration, plaintiff's counsel always has to be mindful of evidentiary and merits issues. Are the claims going to be well documented? How straightforward will they be to prove? What are the defenses? How will the applicability of those defenses and their likelihood of success vary case to case? So sheer volume generally is not going to cut it in the mass ARB context. We need to evaluate evidence and defenses and all the other aspects of any matter standing on its own.
Yeah, that's really interesting because I do think that is probably one aspect of this that makes it a bit unique. And it's something that I think Adam Shenik from the AAA talked about a bit is, what you mentioned, Mike, areas where there could be small individual claims that in the aggregate amount to a very substantial financial outcome. But each one of those claims, if it is to proceed beyond a certain phase in the process, is going to have to be individually proven. So you do need all that. You need evidentiary rigor. You need to be conscious of the fact, as you said earlier, that you have to be prepared to move ahead on each one. So let's talk about that a bit, because I would imagine there's a real cost to that as well, right? So it's not just me showing up at your firm and being like, hey, I've got 10 million potential claims here that could, be really, 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 really successful. You sort of have to look at each one in some respect and say, okay, I've got to track this. I've got to have a basis for filing each one of these. I've got to have evidentiary support for each one of these claims. How do you go about that? And what are the economics behind that? Because that has got to be a very large upfront investment, I would assume.
Yes, absolutely. Those upfront costs and fees can be quite substantial. And as you alluded to, there are changes going on at the big providers, things like flat fees. So again, I won't go too much in the weeds there, but I will say this: on the claimant side, those upfront costs and fees can be very daunting right out of the gate. And in terms of managing those costs and fees, for sure, there's a lot of capital modeling going on before filing. And, firms virtually always work on a pure contingency basis. So it's not the claimants who are bearing these costs, but it is critically important to have strategies for managing the costs and spreading risk on the claimant side, not just pre-filing, but also, as you alluded to, as the matters progress. And I'll just mention one thing that's interesting to me and is increasingly common is the use of third-party litigation funders. And these outfits will advance capital pre-filing and then during the course of the matter to cover some or all of those costs. And the idea is to recoup the investment with, of course, some profit on top when the matter resolves. And I should mention also that many times all of the fees and the costs are not borne just by one firm. It's very common for multiple firms to coordinate on a matter, and then they'll typically have cost sharing arrangements as well. And then just to reiterate, efficient claimant recruitment and claim vetting, again, to me is very relevant here because invalid or frivolous claims can get awfully expensive at scale.
Yeah, you've mentioned a couple of things that are really fascinating, and I want to circle back on that last point you just made in a moment. But before we do, I just want to ask you a bit more about the third-party funding aspect of this, because that is something that has become increasingly important in the arbitration space generally, right? So I started to see that in my practice around, just around probably a year or two before the financial crisis hit in the U.S. That started to become a real meaningful aspect of the arbitration practice. And that's developed over time such that, particularly in the investor state space, if I have a large investor state claim and I'm representing a claimant, I want to announce that I have funding for a host of reasons. One, it shows that there was betting. Two, it shows their support. But three, it also kind of signals that, the claimant is in this for the long haul, right? Like there's no ability to out-resource them in some respects. What types of calculuses are you thinking about when you're thinking about third-party funding for one of these things?
Yeah, that's an excellent question. I think for third-party funders, it's really about, from the claimant's or the claimant firm perspective, it's obviously about risk transfer and capital preservation. So these mass arbitrations may be, and frequently are, very meritorious, but they are incredibly capital intensive and they tie up operating funds. So you, on the claimant side, you want to pursue valid claims, obviously, but what impact does that have on cash flow and earnings for your firm? And so in high cost scenarios like mass arbitration, where filing and arbitrator fees can be very, very substantial, funding can kind of stabilize liquidity for the firm. And in essence, the way I think about it is that, this funding converts litigation expense into more of a structured investment. Now, I should say too that there are many different flavors of litigation funding. The most common, at least that I've seen in my career, is kind of targeted, matter specific funding, which is to say, JP, you have this one arbitration. I have kicked the tires. I've had an outside expert come in and kick the tires without revealing client confidences and such. And I really like the way this looks. So I know that you're going to have substantial upfront costs. I'm going to cover those because I believe you're going to prevail in the end. And you will give me, a return on my investment because we have calculated the expected value of your matter. And so I am essentially funding a single matter for you, and our interests in this single matter are completely aligned. That is changing a little bit. And now funders are now offering portfolio funding where it's not limited to a single matter, but multiple matters are cross-collateralized. And I think the reason why funders like that is because it kind of lowers the effective cost of capital. It can smooth out the return profiles because you don't have all your eggs in one basket. You can monetize claims that are at different stages of maturation. And so portfolio funding can provide a little more predictability and scale. So that to me is just a very interesting sort of cost and risk mitigation strategy on the claimant side. But of course, there are others as well.
Yeah. And that's, it's funny. I have negotiated portfolio deals in the international arbitration space with funders for large law firms because it is a really, just in that context, intelligent way to go about it, right? In some respects, it makes it easier on the investigation stage. You set parameters, you have a pool of funds to operate from. And I think you're right. From the funder's perspective, it does offer its diversification. It offers, as you said, I think maturation of claims, arising at different times and getting returns on different things. It's a really smart way to go about it. So, and it's not surprising to me to hear that would be going on in this space because that traditionally is how a lot of plaintiff/claimant side firms were operating in the class action space, as I understood it, right?
That's correct.
Now, let's talk then just a bit about that point you made about the cost of like an unmeritorious claim. So a lot of the process along the way is developed such that you now have to, as a claimant side firm, you have to provide contact details for each claimant. You have to certify that each claimant has, each claimant's case has been preliminarily investigated, that there's, some merit to each claim. What is the cost of a claim that's not meritorious ending up in the pool for a claimant side firm?
Yeah, that's a great question. And I think this is an area where the kind of industry, for lack of a better term, if you will, has really made significant strides, especially truthfully from the respondent's perspective in that non-meritorious claims are going to be sniffed out much earlier. And you mentioned there are frequently provider requirements of, attestations and kind of validating claims earlier on. So again, that idea that we talked about earlier, hey, I have some clients that definitely have valid claims. I have others where the claims are a little shakier, and then I have wink, wink, some that I don't feel too confident in. Leaving aside your ethical obligations as an attorney, the likelihood that you're going to be able to lump the non-meritorious or sometimes frivolous claims in with the good ones, the ability to do that just has really been diminished, and I do think that that's good. So what that means to me is that claimant's counsel needs to pay very close attention to each individual case as it's coming in the proverbial door. And so in order to do that, firms will invest in proprietary software or other partnerships to generate and automate online forms. And then there are often, bespoke client management tools that make tracking the claims more efficient. And just generally speaking, oftentimes I think it's best to just think of each arbitration as its own matter with claimant-specific information and evidence, but common legal issues that can be tracked across the whole portfolio. But technology has really made coordination easier.
Interesting. And I guess that really, that goes back to that fee bombing point too, at least on the way you were describing it earlier. If you can't fee bomb at the outset and you do have to proceed beyond a certain point, you need to have done your diligence ahead of time. And it's interesting to hear too that the technology is allowing firms to do that, because I have to imagine AI is going to have an impact in this space and how efficiently certain firms can operate. Let me pick up on something there, because I think one of the costs of this that you mentioned, and certainly something that's been surprising to me, is if these do proceed, and I won't go into the process in detail because it does vary from each administrator, but they all generally have some aspect of initial vetting, an initial process arbitrator, for lack of a better term, to be appointed to sort of come up with a plan for how these are all going to get resolved. There may or may not be a mediation phase after that, but if you were to move beyond that without a settlement, and I think statistically most cases do settle at that point, but if you were to move beyond that, you then have to get into actually trying individual cases. Now, one of the ways that some administrators deal with that are batching and bellwether cases. What's your view on that, or how do you feel about batching and bellwether?
Yeah, that's a great question. So just to set the table a little bit, at least how I think of bellwethers is they're representative cases or kind of test cases that are adjudicated first. These, to me, can be very useful to inform valuation on all the other remaining cases. But the key with bellwethers is that you have to have good test cases, meaning that they're actually likely to facilitate informed settlements while, they still have to preserve individual arbitration principles. So in other words, you want truly representative matters, not just multiple versions of the strongest claims or the weakest claims. And ideally, the outcomes in bellwethers will provide data, that's actionable on merits and defenses and damages ranges. So you have sort of realistic guidelines that can guide resolution in other matters. And also, you want bellwethers to be manageable in terms of numbers so that you get adjudications without too much delay. And to me, it is, you mentioned this earlier, but it's safest if the bellwethers are not binding on any of the absent parties, because that can raise due process-like issues and other problems. And I think it's important to note, a bit oversimplified, but one of the key differences between a mass ARB and a class action is that mass ARB you can think of it as like opt-in, and class actions tend to be opt-out, which is to say, if you are a part of a certified class in a class action, you're going to be bound by the judgments of the court, and you're not even there. The particular facts of your individual circumstance are never before the court. They're never going to be before the court, but the class representatives' successes or failures you're going to be bound by them. So in any case, with regard to bellwethers, if they're chosen fairly and wisely, I think they can be incredibly effective. And you mentioned batching as well. And the way I think of batching is that it's procedural grouping for efficiency, theoretically at least. But you're talking often 50 to 100 cases. And batching is sometimes mandated by provider rules or by the arbitration contract itself. And truthfully, my own opinion is that batching sounds nice, especially in terms of volume management, but it can create a lot of headaches. And some courts in California, at least, have struck down contractual batching provisions. So without critiquing too harshly, I will just note that batching sometimes means incredibly long delays for claimants. With batching, you're often talking about, sequential processing of different groups of claims or claimants. And that can really undermine the promise of speed and efficiency that arbitration is supposed to deliver. And without going into details, I will share that I was personally involved in one mass ARB involving employment issues at a massive NGO. And there were people whose claims had been filed 14 years before there was any meaningful step in adjudicating them. And that's just not right. So I'm not a huge fan of batching.
Interesting. Okay. Well, that is, it's funny because that is something that I think it was Liz Carter at Jams and then Mia Levy at CPR talked about that as well. AAA does not have a requirement for bellwether or batching. And I think that was their thought, was that, horses for courses, sometimes it might make sense. But I do see the challenge to batching in particular. And certainly 14 years is, justice delayed is justice denied. So I think that is that's a really fair point. Well, then let's talk about the future of mass arbitration a bit, because I think it's an interesting segue. One of the struggles, or one of the things that came out of the previous three guests was, these procedures are evolving. AAA in particular had said, look, the reason we don't have requirements for things like bellwether and batching is because we think that this may, there may be instances where cases present themselves where that would not make sense. We don't want people bound into that, but we recognize the value of it. So, if it's good, a process arbitrator can include that possibility. So let's talk about that a bit. What do you see as the future of mass arbitration from the claimant's perspective?
Yeah, I think mass arbitration will be around at least as long as class action waivers dominate in consumer contracts. I'd like to say as well that, to me, mass ARB is not a loophole. It is contractual enforcement at scale. If bilateral arbitration is required in a contract, then the drafter of that contract really shouldn't be heard to complain when arbitration is invoked, even when that happens thousands of times, basically simultaneously. But in any case, empirical reality shows that mass filings remain robust, and settlement rates are often comparable to individual arbitrations. So the mass ARB animal still has real teeth. And the future is promising, but I do expect, as you mentioned, JP, I do expect mass arbitration to continue to be contested, continue to adapt and evolve.
Now, do you think that, because one of the inherent questions in what we're both saying is, will corporations, and I think it's probably driven more by corporations, as you mentioned with the drafting, will they continue to use mass arb as, for lack of a better term, a risk management strategy? Do you have any views on that? Do you think it's going to stick around, or do you think it's just this batch of contracts that have been drafted and they'll start to phase out?
Yeah, that's a great question. I think you're already seeing, and actually have seen for a few years now, some corporate countermeasures to what we talked about before, the pure, fee pressure playbook that was common and frankly pretty effective only a short while ago. But I'm talking now about arbitration agreements with pre-filing exhaustion requirements and sequential batching provisions and other, provider specific clauses that, to me, they're basically designed to delay resolution. I am biased, but there also have been at least some attempts to litigate against plaintiff firms for abusive or fraudulent filings. But all of these issues continue to be scrutinized in courts. And as of today, there hasn't been any blanket shutdown of mass arbitration. And honestly, I'd be quite surprised to see one. So I will just say from the claimant side that I see it evolving from a kind of fee hammer strategy a few years ago to something that is much more nuanced and, maybe intellectually more sophisticated, but a strategy that's much like MDLs in the class action world. So those strategies will have to account for many of the items we've discussed today, like volume and batching and mediation leverage and, selective merits litigation. But all of this, honestly, is just my best guess.
Yeah, no, and that's I think all anybody can offer at this point, because you've seen pushback from, some pretty notable corporate clients, like one large online retailer decided to go back to litigation. Others have made changes to their arbitration provisions. I think, at least from my perspective, that the safest guess is to say it will continue to evolve, and everybody's got to keep an eye on how it develops, because you've got really smart people on both sides of the coin trying to counteract what everybody else is doing. So it's a really fun game of cat and mouse in some ways. Any thoughts about anything that institutions could do to improve their rules?
Yeah. You've alluded to this. I know some of your previous guests have spoken to this, but I think institutions already have made rules changes that improve predictability and transparency. I think even clearer timelines and things like, standardized evidentiary frameworks would frankly benefit both sides in my estimation. But the introduction of process administrators, mandatory global mediation windows, and some of the batching and Bellwether style procedures that we touched on earlier are a very good start.
That's great. Well, I think that's been a really, really, really fascinating discussion that's involved a lot of really great information. And I suspect we're going to be turning back to Mike in a year or two to follow up and hear how some of these developments have played out. But with that, I think we'll conclude our discussion of the claimant's perspective on mass arbitration. I want to thank our guest, Mike Hartmere, for sharing his views on the topic. And I want to thank you, the audience, for listening. You should feel free to reach out to Bracewell about today's podcast with any questions you might have, as well as to Mike. And we look forward to having you tune in for future episodes in our Arbitration Acumen series, and particularly the other installments in the Mass Arbitration mini-series. And let me just say a personal thanks again to Mike. It's really been fascinating. We really appreciate your time and your perspective, and thank you.
Thank you for having me, JP. It's been a real pleasure.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.